You're all done. I gave it to you on February 19th. No. You're all done. 90 days.
Oh, come on. I'm just getting my stuff together. Days. I've been doing, you said we're going to just put that aside right now and worry about the other stuff. We'll worry about the other things. Okay, so no. Come on, please.
90 days.
Back in February, this defendant was granted an unusually favorable opportunity, a chance to avoid harsher consequences and remain in the community under supervision. Yet in a remarkably short span, that opportunity unraveled into a string of violations. Failed substance tests, incomplete or missing documentation, and explanations that fail to hold together have now brought him right back before the court. Despite the clear conditions attached to his release, he appears to frame these lapses as small mix-ups rather than serious breaches. Issues involving drug screening results, unverified employment records, and gaps in required reporting are being portrayed as harmless confusion. From the court's perspective, however, those are fundamental responsibilities tied directly to maintaining probation status. Community supervision is structured around a few straightforward expectations: remain substance-free, attend required check-ins, and submit accurate paperwork on time. When someone receives that level of leniency and then disregards those basic terms, it raises questions about accountability and judgment. With that context in mind, the court now takes a closer look at how the second chance was handled.
Record in the matters 20 CM 234, 21 CF 130, 21 CM 199, State of Wisconsin versus Benjamin Flannery. The state appears through DOC agent Leah Lineweber. We have Mr. Flannery in person as well. We're set here today for a probation review hearing. We were here on February 19th, in which the court did provide specific orders and conditions for Mr. Flannery to meet to avoid having conditional jail. He was serving some conditional jail or in custody on a warrant and facing conditional jail. At that time, the Department of Corrections had another individual, Gretchen Anibis, in your place, Ms. Lineweber. That is not the agent of record. You were on vacation. And so she had notes about the case, and there was a recommendation from your standpoint and Department of Corrections standpoint. But now you are back from vacation, and you can provide the court with an update on where we are now from February 19th and where Mr. Flannery is and if he is actually meeting the conditions of the court.
He is not meeting the conditions of the court. He showed up on the 28th of February and he admitted to using methamphetamine.
I'm sorry, I have to turn you up a bit. Go ahead.
You want me to repeat?
Yeah, no, you don't have to repeat, but okay. Can you bring the microphone just a little bit closer?
During that office visit, he was told about the GED boot camp. He did fill out the paperwork while he was in the office, and we did email it to the GED boot camp to make sure it got there. He did come back on the 14th, and he was positive for marijuana, and he stated that it was not new use. But I did not realize at that time that he didn't test positive, or he didn't admit to it when he came into the office the first time. So I believe it was probably new use, but he was negative for methamphetamines at that time.
He didn't even make it 2 weeks before producing a positive test result. That kind of timing doesn't point to pressure or circumstance. It reflects a choice made almost immediately after being granted another chance. When someone returns to prohibited behavior that quickly, it suggests the conditions of release were never taken seriously from the outset. Moments after leaving court with leniency, the expectation is renewed caution and compliance, not instant relapse into violations. Using again within days undermines the very purpose of probation, which is meant to serve as a turning point and a structured path forward. Instead, it can appear the opportunity was treated casually rather than as a lifeline, that if supervised freedom isn't enough motivation to maintain compliance for even 14 days, the court is left questioning what, if anything, would encourage change. Framing that outcome as misfortune overlooks the underlying issue, a lack of discipline and disregard for consequences. From a judicial perspective, such rapid noncompliance weighs heavily when reconsidering continued leniency.
He has not handed in any of the job logs, but he did state that he was hired full-time with his wife's uncle, I believe. He was told that he needed to bring in documentation, like fill out the days and the times and have the boss sign it, verifying that that's what he worked. And he was supposed to bring it to court today. and he has not.
Okay. Mr. Flannery. All right. So you were here in court on the 19th. You then saw your DOC agent on the 28th, and you admitted to consuming methamphetamine, correct?
Correct.
So from February 19th, in which you were in court, and the court set very strict conditions and did not order conditional jail, you used methamphetamine between February 19th and February 28th, correct?
Yep.
And then between February 19th and March 14th, you used, at least you used THC marijuana, correct?
Correct.
Now, I have a notation that you've paid in your probation cases, is that correct? Have you made any payments?
Yeah.
When did you make payments?
I made after the first 2 weeks, because you said $50 a week. After the first 2 weeks, I paid $100. I paid $50 last week, and I have $50 this week, Friday.
All right, but you still owe a significant amount.
Yep.
All right, you understand one of those conditions that the court did order was absolute sobriety. Understand that?
Yep.
I mean, that is one of the conditions, not only that is part of why you were not ordered for conditional jail on February 19th, but that is one of the conditions for your probation. You understand that? Understand that?
Yes, I do.
Okay. And so now we have two admitted uses of not only THC, but methamphetamine. And we're talking February 19th to February 28th is not that long in time, right?
Right.
Ms. Lineweber, is there a recommendation from Department of Corrections?
There was not.
You don't have a recommendation?
No, I'm sorry. I just assumed we would bring it to you and then you would decide what you
Okay.
wanted to do.
Mr. Flannery, is there anything that you want to tell the court or you want to let me know?
Yeah, I mean, the drug use, I guess I understand it was a rule that I broke, but it was more of a slip up, and I'm doing pretty good.
Your eyes look kind of bloodshot right now.
Yeah, it's windy and cold. I've been outside all morning.
If I get you tested right now, you're not going to test positive?
Attributing bloodshot eyes to nothing more than windy weather during probation hearing is an explanation the court is unlikely to accept at face value. Physical signs that often raise concern about substance use generally require a far more credible account, especially in a supervision context. Presenting such a minimal justification risks undermining a defendant's overall credibility before the judge. Experienced court encounter a wide range of explanations for noncompliance, and they tend to measure them against patterns seen repeatedly over time. When a statement sounds implausible or poorly supported, it can appear dismissive of the seriousness of the proceeding. That perception can be as damaging as the underlying violation itself. Judges and probation officers are accustomed to evaluating consistency between behavior, appearance, and reported conduct. When those elements don't align, outcomes rarely favor the person under supervision. Situations like this often reinforce the court's concern that the individual is not taking conditions or the opportunity for continued freedom with the required seriousness.
Okay. What else?
Well, now that I've been working full time, I can make my payments for sure.
And who are you working for?
M5 Construction is the company. His name's Kevin Miller.
Oh, I know Kevin Miller.
Yeah.
And who is he to you?
He's my uncle-in-law.
So I have one memorandum from the Department of Corrections from March 17th. I had another memorandum, but I don't know which file that was filed in. But I do remember there was another one filed from a different date prior to the last probation hearing. Maybe it was just what Ms. Annabis told the court. Did you file a memorandum prior to the last hearing?
I did, requesting the hearing.
Requesting the hearing. Do you remember what date that was?
I do not. I'm sorry.
Oh, that's okay. Oh, was that in December?
Very well could have been.
Yes. December 23rd, 2024 was a memorandum requesting a hearing. He wasn't paying his fines and fees. He didn't get his GED. He didn't complete the AODA. Oh, that's another reason. That's what we discussed, the AODA last time, and with the absolute sobriety. All right. Anything else that you want me to know, Mr. Flannery?
I guess not.
All right. Well, based upon what occurred on February 19th and based upon what occurred between February 19th and today, the court is going to order 90 days of conditional jail. to start immediately today. You'll be taken up right now. 90 days conditional jail.
Can I get one more?
Nope, you're all done. I gave it to you on February 19th. You're all done. 90 days.
Come on, I'm just getting my stuff together. I've been doing.
I gave you leniency on February 19th.
Give me a chance at least to.
I gave you a chance
I know,
on February
but
19th.
please, come on, please.
I gave you your chance on February 19th.
Please.
You have not done your AODA since I sentenced you, Mr. Flannery.
You said about the AODA.
When did I sentence you?
You said about AODA. Remember, you said we're gonna just put that aside right now and worry about the other stuff. We'll worry about the other things. Okay, so I'll do the AODA.
Nope.
I'll do the AODA then.
90 days.
I'm signed up to do my
We're
GED.
adjourned.
Your Honor, please, come on.
90 days.
No. Come on, please.
90 days. 100 days.
What?
You just swore. 100 days.
This outcome often follows when someone mistakes an additional opportunity for unlimited tolerance. Community supervision can appear manageable at first, but its seriousness becomes clear the moment conditions are ignored. Courts generally recognize that people can make isolated mistakes. Frustration grows when behavior suggests there was never a genuine plan to comply. The extra 10 days imposed for courtroom profanity wasn't really about a single word spoken in frustration. It reflected the broader attitude displayed toward the court and its authority. Repeatedly testing boundaries tends to signal disregard rather than error, and that distinction matters greatly in judicial valuation. When someone keeps edging past established limits, consequences eventually respond in kind. In this case, the privilege of remaining free was available, yet it was not preserved through responsible conduct. Share your thoughts on the ruling and whether you believe the response was appropriate. Thanks for watching. Be sure to like, subscribe, and take care.